kind of divert for just a second and tell you that I have known Tom Lee since before he was a lawyer. Yeah. That, the first time our paths crossed, I was a member of the school board, and he was a Channel 5 news reporter interviewing me. So,
we've both come so far.
I know. Who knew?
Short period.
Yeah. And who knew it had to be at least, what, 33, 34 years?
Yes.
Later? That we would be serving on the Charter Revision Commission. I don't know if that's a good thing or a bad thing, but anyway, thank you for
Good to be here all the same.
yeah, for being willing to serve. So, okay, at this time we'll open the public comment period. Understand that several people have asked to be allowed to make comments, and if you would, if you'll just call their name in the order that they signed up, and if you'll state your name and your address for the record purposes, we would appreciate that.
Sure. First, we have Mr. Shane Smiley.
Good afternoon, Shane Smiley, Brush Hill Road, Nashville. Ladies and gentlemen of the Commission, I appreciate your time in being here this afternoon. I'm going to make this brief as we go through this process, and I'd like to see if this Commission can do their best to encourage truth in advertising as things move forward. Let's start with the name of the organization that's filing this position, Restore Our Fairgrounds. Well, it looks to me they're trying to destroy the fairgrounds and doing nothing as far as restoration. There was a recent story on WKRN. Heidi Favorite, one of the members that has signed this petition, made the comment that the fairgrounds was originally given to the people for public space. As an individual who's been involved in this process and actively attending fairground meetings or fair board meetings since 1997, and have done a great deal of research on this subject, I've seen the deeds that are available, and which cover about 95% of the property. I've seen nothing in those deeds that indicate that it was ever given to the people in Nashville, nor there's any evidence that it was ever public open space. So the claim that is being put out to the media that this is misleading to the people of Davidson County. It was never public open space. It was never granted or gifted to the people of Davidson County. So I hope as they move forward that they'll be honest with the narrative that they're going to put out and change their ways, because what we've seen in media to this point has been anything but honest. They're not trying to restore the fairgrounds. They want to destroy it and redevelop it for commercial use. And again, the fairgrounds was never given to the people of Davidson County. It was purchased, and I have all those deeds and the time frames present if you'd like them to be added to the present record. Thank you for your time.
Thank you, Mr. Smiley. So who is next?
Next, we have Paris Coleman.
Good afternoon. My name is Paris Coleman. I reside at 2305 Cooper Terrace, Nashville, Tennessee, 37216. I am born and raised, and I am a native here. And I'm fighting for the cause of Make Nashville Fair again.
Can you come in just a little closer? I'm not sure the microphones will pick you up. So.
I'm here on behalf of Make Nashville Fair again for the Labor Hall, Leona, Local 386. We're here just fighting for the rights of just a future project to keep Nashville local, the neighborhood local. Everybody that's really a part of this project is just wanting to keep Nashville, you know, home. It's morale from the neighborhood. It's morale from the city. You know, the racetrack was built in 1904. We're talking 2026 now. We don't want to get rid of something that brought so much here. Myself, growing up here, 6 years old, MPS giving us free passes to go to the racetrack and being introduced to a whole new world versus just country music. So for me as an adult now, I want to be a part of demolition. I want to be a part of the remodel. I want to be a future project. With that land, we can open so much. There's not a community center in their neighborhood anymore. We got to think about the elderly that's there that needs a track to walk around. Yes, it's a dog park there, but what about the neighborhood that's there? Thank you for your time.
Thank you, Ms. Coleman.
Next is Terrence Moreland.
Good afternoon. Good afternoon. My name is Terrence Moreland. I'm a member of Leona. I'm an MC3 graduate. I've been going to the fairgrounds my entire life as a kid and the Speedway, going to see races. The first fair I've ever went to was at Nashville Fairgrounds. And I know it's a old establishment or whatever, the infrastructure is old, but I don't feel like the right thing to do would be get rid of it. I think the right thing to do would be rebuild it, make it better, because it's one of the things that made the people of this city fall in love with the city. I would love to be able to take my kids there for an event and just share that relationship with my kids. Thank you for your time.
Thank you, Mr. Moreland.
Thank you.
No
Anyone
additional
else?
speakers.
Okay, then we'll close the public comment period and move into the next item on the agenda, which is the approval of the July 12th, 2024 meeting minutes. Has everyone had an opportunity to review those minutes? And if so, hopefully you have. And if so, we need a motion to approve or modify the minutes.
So moved.
Second.
Okay, I hear a motion by Mr. Harden. I heard a couple of seconds. So Ms. Short-Jones, so we've got a motion and a second to approve the minutes of the July 12th, 2024 meeting. All those in favor, please say aye. Aye. Any opposed? Then the minutes are approved unanimously. Next, Ms. Ecke, do you do the appeal rights, or does Austin do you?
I do that.
So we'll have the notice of our appeal rights. Are there anyone else's appeal rights, not ours?
Parties wishing to appeal a decision of this commission are encouraged to engage independent legal counsel to determine the appeal rights and deadlines. Generally, appeals of metropolitan boards and commissions are initiated by filing a writ of certiorari with the Davidson County Chancery Court. A decision by this commission to certify or not certify a petition may be appealed to the Davidson County Chancery Court by filing a writ of certiorari within 30 days after the decision of this commission.
Good, so everyone understands what, if they're not happy with our decision, that you've got an option to take it to another entity. Okay, at this time, we'll move on to considering the charter petition that was filed by Mike Kopp and others. I think traditionally, we've always allowed the proponents of the amendment to describe and explain a little bit about what it would do. And then from there, we'll move to the Metro Legal Department concerning their opinion on the charter amendment. So I don't know who wants to speak.
I'll go first. Thank you, Mr. Chairman. My name is Mike Kopp. I'm a longtime frequent registered voter in Nashville and one of the 10 petitioners who initiated this process last month pursuant to the Metro Charter. Even though 10 individuals signed the proposed petition that's in front of you, our pro-referendum coalition is much larger. 16 organizations representing thousands of Nashvillians who are hoping the voters can decide the future of the Nashville Fairgrounds Speedway site. You should have received a one-page document that provides an overview of our Restore Our Fairgrounds Coalition, which includes what we call the Fairgrounds Community Commitment. I'm not going to chew up the limited time by trying to filibuster on our pro-referendum coalition's overall goals and objectives. You can learn more about what we're about at the restoreourfairgrounds.org. Joining me today is my friend and fellow petitioner Saul Solomon, who also serves as our coalition's legal counsel. For today, Saul and I are simply here to explain the components of our proposed petition and answer any questions you may have, and to urge you to certify the petition as meeting the requirements of the Charter. Before I explain the two components of our proposed petition, let me very briefly recap the history of this conversation. As you'll recall, an earlier iteration of our pro-referendum coalition brought forth a similar proposed petition in early 2024, which was certified unanimously by this commission. Unfortunately, we weren't able to circulate that petition during 2024 due to a lawsuit that was later dismissed by the Davidson County Chancery Court. While we were disappointed that our previous effort was stymied, we remain undeterred, and we use the intervening time to recalibrate our approach and bring you what we believe is a more thoughtful petition. Let's face it, the Nashville of 15 years ago, which is the last time voters had a chance to weigh in on the fate of the fairgrounds, is a much different city than today. Affordability is now the most important issue we face. And so we believe the public at large should have a seat at the table when it comes to deciding how we utilize precious city property, which is owned by the taxpayers, instead of any kind of backroom deals being cut with out-of-state corporate interest. The two basic components of this proposed petition are as follows. First, We would ask voters to remove the term auto racing from the list of required activities at the fairground and replace it with a language that would allow for affordable or workforce housing as defined by the Metro Code of Ordinances. Second, we would ask voters to adopt a new provision requiring the Fair Board to take steps to ensure that no auto racing occurs within 1,000 feet of Browns Creek, which is one of the most polluted streams in Tennessee and circumvents the entire county. Polluted, not coincidentally, by automotive pollutants, including oil and grease. While we understand that the Commission's role is not a policy-making body per se, we nevertheless want to assure you that we believe our proposed petition represents sound public policy. And we certainly believe it's consistent with the requirements of Section 19.03 of the Charter, which governs amendments by petition. Finally, we'd like to thank you for your public service. Many of us have been public servants, and we know that it's a thankless job. But it's important, and we appreciate your efforts on behalf of our community. With that, we stand ready to answer any questions you may have and accept any feedback you have.
Does anyone have any questions of the petitioners? If not, then,
I do.
oh, sure.
There was a reference made earlier that's about who owns it. My understanding from that is it's not commons ground, but it's viewed as commons ground. But your statement makes me think that it is Metro owned. So where,
Yes.
It is Metro property.
Metro property now.
but it's not considered commons ground.
The parts of it are leased out to other interests, yes. Yeah. I don't know if that answered your question.
Well, I'm talking about common ground like we talk about in Boston.
Oh, right, no.
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 Okay.
Yeah.
Thank you.
Great, good, thank you. And I'll say, before I turn it over to Ms. Ecke, I appreciate, Mr. Kopp, you saying that really we're not here to determine the legitimacy of the policy of whether you have racing at the fairgrounds or whether you have affordable housing or any other use. Our role is to determine whether or not the petition as filed meets the requirements of the Metro Code as far as amending the Metro Charter and meets the requirements of the Metro Charter. So while I appreciate, what everyone has to say about it, that is an argument more for supporting or opposing the petition if it gets on the ballot. So we're not really here to take a position on that. So I don't want anybody to feel like, well, we're for it or we're against it, because we have to determine whether or not the petition is filed meets the requirements. And if it does, then it goes on the ballot, and everyone can be welcome to make all those arguments in the public sphere. So we do have a legal opinion.
Chair, can I ask one question?
Sure.
That I just thought of, and Mr. Kopp, you said last year we had a similar amendment that was approved unanimously that then got tied up in litigation. But the amendment last year didn't include the prohibition of having any auto racing within 1,000 feet of the creek, correct?
That's correct.
So, that's a significant difference from what we looked at a year ago, because if that passes, it in effect means auto racing has to terminate, whereas before, what the language said was that basically auto racing was protected, but if we had amended the charter, if that had passed, the Fair Board wouldn't have had to have eliminated auto racing. Under your amendment, they would, correct?
That's correct. And if I may, if it helps, one of the reasons why that language has been added this time is since we went through that process a year ago, one of the organizations that's joined our coalition is the Cumberland River Compact. And they brought all, the knowledge and influence of their environmental assessment, and that's one of the things that they asked to be included.
I understand. But my point is, this one is different than what we considered a year
That is
ago.
correct.
So what we did a year ago may or may not. And again, I don't recall, but I think all we did a year ago was approve the form of the petition before,
Exactly.
right?
That's exactly right.
We never got to a vote of whether we would recommend or not recommend based on the substance.
Correct. We just
We
approved
just
the
approved
form
the
and
form.
substance, and then
Right.
then it went into litigation, so.
Right. I mean, just so everybody understands, the charter was amended a few years ago to say that if you're gonna do a petition, before you can start collecting signatures, you have to jump through a hoop of coming before us, and we have to evaluate the petition based on criteria that are contained in the charter. And those criteria don't have anything to do with whether we think it's a good amendment or a bad amendment. It's whether you meet certain requirements to be able to put it on the ballot. And so that's what our role is here, is really, do you meet the criteria? And there is a process, if we say you don't, where you can come back and I think last time that's what we did, as I recall. The original submission was not in the proper form, and we told them, no, you have to get it in the proper form. And they came back, and then we approved it. So, I mean, there is a process. We adopted procedures last year to go through all of this, and they set out the process that we go through to review these amendments, and that's what our role is today.
Good. Thank you, Jim. That was a good analysis of the difference and
Well, I heard him say that, and I was thinking, I don't think the Browns Creek prohibition was in it last time.
That is correct.
And that is a difference, although it's not, I'm not sure it's a difference that really matters in our,
for what we're doing.
what we're doing, unless it triggers one of these criteria in the charter that would somehow say we can't approve it because it's got something in it that we can't approve. But I don't think that's an issue, that's not an issue that we've heard from Metro Legal. So, at this point, that's all I have to say.
Thank you. And again, I appreciate you reiterating what our role is. Some of my friends are for it, some of my friends are against it, and I'm for my friends. So, at this time, I'd like to hear from our legal counsel who has, the Metro Legal Department has provided an opinion on the validity of the petition. And Ms. Ecke, I don't know if everyone has seen that yet or not. But if you would sort of explain the Metro Legal Department's position on this petition, so that for the benefit of the commission, and then we will go from there.
Sure. So as you indicated, there is the legal memorandum, and there, as indicated in the legal memorandum, there is one issue. The proposed amendment adopts the definition of affordable and workforce housing in the 2026 version of Chapter 2.213 of the Metropolitan Code. The problem with that is that Chapter 2.213 of the Metro Code expired on July 2nd, 2024, and has been null and void since that time. So the charter requires that the proposed petition convey a reasonable certainty of meaning, and provides that the commission shall not certify a petition that fails to convey a reasonable certainty of meaning. So it's the Department of Law's opinion that this proposed petition does not comply with that requirement in the charter, because it fails to convey a reasonable certainty of meaning with regards to its definition of affordable and workforce housing, because it adopts a definition that doesn't exist and has been null and void since 2024.
Anyone have questions of Ms. Ecke?
I have a couple of questions, Mr. Chairman. And one is a preliminary question that I don't think is addressed in the legal opinion. And this is an historical question, so I'm privileged to be the youth movement on this body. So,
Be careful what you say.
You'll excuse me. You'll pardon my inexperience. But the charter says that the city can only have one referendum every 2 years, as I understand it. That's the result of a citizen petition, correct?
Correct.
When was the last?
Oh, it's been more than 2 years,
More
for
than
sure.
2 years.
Yes.
So, and my math would tell me that if this were to go on the ballot in 2026, we'd not be doing another until 2028.
Correct.
Maybe not even by the election of 2028, depending on how long 2 years runs, right?
Yeah, it's exactly.
2 years is 2 years.
Correct.
Second question really goes to the opinion. Ms. Ecke, is it the legal department's concern that the language to which the petition refers is no longer part of the Code of Ordinances?
Yeah, exactly, yeah, because it adopts the definition in the 2026 version of the code. Well, in the 2026 version of the code, that definition doesn't exist because that definition expired way back in 2024, has been null and void since that time, and is no longer part of the code. It's not part of this 2026 code. The code has a sunset provision.
So my second question is something of a what-if question. Imagine that the provision was still had force of law. The ordinance, I mean, still had force of law. What do you think then about having a provision in the charter that references a section of the Metro Code?
Mm-hmm.
My concern is, I'll just jump to the chase, my concern is the charter is hard to amend, but the code is not. And if the charter refers to a section of the code, well, for definitional purposes, then a simple vote of the council could change what the charter says. Because the council could choose to change the definition of affordable housing if it so chose. Assuming, again, the provision were viable at the moment. So, I guess there's a third concern with that. We're about to see a constitutional amendment referendum in Tennessee this year that I submit no one's going to be able to understand, having to do with allowing judges to deny bail. And one of the reasons they're not going to be able to understand that constitutional provision when they see it on the ballot is, as certified by the Secretary of State, it's going to say certain offenses are no longer, well, you can deny bail for certain offenses, and it'll be done by reference to a section in the Tennessee Code. So unless you carry your green book with you into the ballot box, you won't have the first idea of what that provision means. So whatever the outcome is here today, my hope is, as we see provisions come before us, that they actually have the language in the provision as opposed to, and I know it can clutter things up, but I'd like to make the charter harder to amend and not susceptible to amendment by just a vote of the Metro Council, because they want to change a definition, which they can and should. You're right. It's not the same city. And it won't be the same city 5 years from now or 10 years from now. Those are all my questions, Mr.
Very,
Chairman.
very good point. It kind
Yeah.
of leads into my question. And I know it's a little bit of a hypothetical, but if the,
You get to answer my question after you answer.
Is yours a question or a comment?
Well, both. I'm interested in your thought on it. I'm interested in your, I'm sorry, Mr. Chairman, but I'm interested in the department's thought on whether it's appropriate to include language in the charter that makes reference to language in the code, which is easier to amend.
Well, let me say this. I don't want to speak to issues that are beyond the scope of my role today. What we do, we look at the particular language that's been proposed and see whether it's consistent with the requirements of the charter. What may be best practices,
That's our job.
there are opinions about
Cross
what
that
may,
bridge when we get to it.
what may be best practices. That is, generally, if you have a constitution, you generally don't define terms in a constitution with subordinate laws, But again, I mean, that's an issue of best practices as opposed to is it legal or not. Yeah.
Whether it's susceptible to a reasonable certainty of meaning.
Yes.
Can I make
That's
a,
a very lawyerly answer.
can I make a comment here? Because I think it's a really good point that Tom has made. And I think he laid out kind of the yin and the yang. On the one hand, you could say, and there are provisions in the charter that say this, that, as determined by the council, there are things that are deferred to the council in the charter, like the creation of the departments and things like that. Those things were authorized in the charter, but the specifics are set out
Requires
in
an
the
ordinance
ordinance
to
of
make
the
it
council
effective.
to do it. So you can do that, and I think, but the other point that you make is, for something that's important like this, do you want to really expose the definitions to the will of the council, or do you want that to be something that the voters have a say in? And if you take it, put it in the charter, then obviously it can only be changed by a charter amendment. If you don't, and leave it to the council, it can be changed by an ordinance of the council. So I think that's a really good point, and I think it's something that, from a policy standpoint, I think that is something that we could say we're gonna be critical of things that don't do that. That's, each one of us could have a different opinion on whether it's better for the council or the voters. But I think that's something that comes down to this. I mean, I think the concern when you take it out of the charter is what's happened here, which is you've got a reference to a provision that goes away. And, frequently I find legislation that refers to older or other legislation, and you go and look for that other legislation, and it's no longer there anymore. And that's a real problem, is, again, what happens when it goes away? Determining the intent of the voters is really hard in that circumstance. So I think there are pros and cons here. I think this is an easy fix. I mean, you just add the definitions into your petition, and it's fixed. And, so I don't think this is hard. I think Metro Legal's raising a really legitimate question, which is, if it doesn't exist now because it's no longer in the code, is that something that violates one of our criteria, which is, it's uncertain of meaning? And so I think that's the real challenge. You're in the nitpicky committee here,
No,
to some extent.
You're making the same arguments I made to some of my colleagues. Believe me, I'm listening to you.
So I think I don't want to be in the nitpicky committee, but I think from the standpoint of what the charter charges us to do, it does require us to do some of that. And as Tom points out, you could solve it two different ways, and probably we could say either of them would work. One of them would require the council to adopt a definition, versus another one would put it in the charter and be baked in and would have to be changed by a charter amendment. I think those are kind of policy choices at some point, but, if there's no reluctance in putting it into the charter, to me, the simple answer would be just add the definitions, and
Then it's clear.
then we're done.
Yeah.
Yeah, because then it's like, go get your signatures and see if you can pass it on the ballot. Because at that point, you've satisfied the nitpicky committee's requirements that you don't have something that's confusing. And I think that's the thing that this charter amendment, the charter amendment that created our role in reviewing petitions, that was one of the primary reasons behind it, was a criticism that some prior charter amendments had been confusing. And so I think that we take pretty seriously that our goal is to not have any confusion.
And I think as a policy statement, we can say whatever the definition is, make sure it's clear. Following up, did you have anything you wanted to say in response, Nikki?
No,
I guess following up, my question was going to be, and I know it's a little bit of a hypothetical, but if the charter amendment referenced a definition as of a certain date, just in a vacuum, not specifically this charter amendment, but if a charter amendment said, relying on the definition of X as it appeared in the 2023 code at this section where you have a snapshot in time, would that, in your general thought process, not necessarily a binding legal opinion, would that be sufficient for certainty?
Yeah, again, not necessarily a binding legal opinion,
Yes.
because we do review each proposal as presented. So with that caveat, that on it, in and of itself, doesn't appear in general to be an issue. But again, it depends on the specific proposal.
And so I guess there are a couple of questions. One is, do you rely on something at a particular point in time, or do you reference it as it may be in the code subject to change, which...
And again, my only concern with how you do it is, how do you change it, okay? So if you reference it based on the code as of a specific time, and that code section somehow goes away, how do you change it? Is that a charter amendment that has to change it? Because the language isn't in the charter, it's in some other document. And that's kind of the challenge with referencing language in other documents is, over time, they go away or get changed. You know, you say everything, we say we'll reference the language in section 103.5B, and the council comes in and renumbers all the sections. It's still in the code, it's just not B anymore, you know? What happens then? And so that's kind of, I'm guilty of this, okay? I've done this before. That's part of the reason why I know about this problem.
Do as I say, not as I do.
Well, no, I've learned my lesson. This would be what I would say is, you know, you get caught into doing things like that because it's easier to reference than to basically reproduce it in your own document, or you want the ability to change it in the future without going back to the legislative body or the same legislative body. But yeah, I mean, there's pros and cons, but you know, I'm always reluctant, particularly with a charter. I mean, it's one thing when you're talking about an ordinance or state legislation, but a charter, to me, I think Tom's point is a good one, which is, you know, it's a better practice, I think, to have it in having the definition in the charter, so that you know that to change it, you gotta go and get the charter changed. That's just that's my personal opinion, for what little it's worth.
When I was reading this yesterday, I wondered if you were actually helping us to see that there could be a lawsuit filed, which means everything just gets held up because it wasn't defined right. And by recognizing that we don't need to just go ahead and approve something that would cause something to go into a lawsuit and delay everything, that shouldn't be what we do. That was part of my reading yesterday.
Well, and I think that's a good point, because we just had that happen,
Yeah.
you know, a year or so ago with the last time. And so, again, that was part of what this provision in the charter that said we're supposed to review things in advance was put in the charter to try to reduce those lawsuits, or at least to have them occur before you go out and collect all the signatures, so that the public knows that it's been blessed by this committee. And then if somebody appeals, because we can't prevent somebody from appealing, somebody might appeal, but at least we get that resolved before you go out and collect the signatures and put it on the ballot. The idea was, don't do all that, don't have an election until you know it can be done. And I think, again, I think that's Metro Legal's goal here. It sounds, that was my read of your opinion, was don't approve something that might put us in the same position we were a year and a half, 2 years ago, whenever it was, late 24, whenever that we did the one before, so.
Okay. Zeki, if you would just sort of reiterate for our benefit, our role at this time is either to approve or disapprove the petition as presented. That's all.
Certify or not certify?
Certify. Thank you, that's the language.
Is it possible to ask a question?
Sure.
Okay. We don't want to waste people's time, and so we've heard feedback on this particular section, and we are gonna file an amended petition. I am taking the opinion to mean that, other than this particular section, there were no other deficiencies with the petition. And I don't know if that's an appropriate question or not, but that's kind of what, we don't want to file something and then we all get back together again, there's a different issue that Metro Legal may raise. So to the extent that the language stays, just focusing on this petition, from a legal perspective, my question is whether any other deficiencies.
Well, looking at the particular petition, this was the one deficiency
This is the one deficiency.
in this particular petition.
Right.
Yeah.
Yeah, understood. Thank you.
I think what I am interpreting you saying, Saul, is if you leave the language the same except add the definitions.
Yes, correct.
Will there be anything else that comes up?
Yes.
And I would say to this, probably not. But at the next meeting, if someone else comes in and identifies a problem that we have not identified or Metro Legal hasn't identified, I'm not gonna say to you, okay, we said last time there weren't no other problems, so we gotta approve this. So you can't box us in like that.
It's not an instruction that if you fix this one issue, the whole thing
Understood.
Goes away,
would
but
be approved.
But there's
But
immediate
so far,
feedback.
we've not
Right.
seen another issue,
Yeah.
but if someone comes in and raises another issue, then we're gonna give that our consideration, because I think
Yeah.
they're entitled to that. I mean, again, it has to be on what we're doing here, which is this petition meet the criteria
Right.
in the code, in a charter? If
Right.
it meets the criteria in the charter, then I view that we have to approve it, that we don't have the discretion of saying we don't like it. That's not our role. Our role is to make sure you meet the criteria.
Right.
And then, but if someone comes in at the next meeting and says, well, last meeting, y'all didn't even think about this, and we sit here and say, yes, no, we didn't, we're sorry, but now we are, I'm reserving the right to do that.
Of course. Thank you for that
But
clarification.
I just,
We understand that.
I think that just,
Perfect.
well, it's not just for you, it's the other people in the room too.
Right.
I want everybody to understand that we're gonna listen to if someone else has a problem when we come back here.
As a guy who once lost a matter before the beer board by 7 inches, I am anxious about a provision saying 1,000 feet from Browns Creek. I don't know what Browns Creek is. I don't know where it is. Are we measuring from the middle of Browns Creek? Are we measuring from the bank? Is it the Corps of Engineers property? Is it somebody else's? I don't know. I was told I was 7 inches too close to Hattie Cotton School to get a beer permit. That's all I know. So I
Point taken.
I'm just saying.
So, I mean, I think that's the kind of issues that we might spend more time on next time.
I was on the beer board.
Just by way of coming to Jeff.
Make Tom comfortable that, you know, he understands what 1,000 feet means.
I just don't want to go back to the beer board.
Well, I was on the beer board for 8 years, so I hope you didn't come.
We're not, Ms. Sims, thank you. It was other terrible people.
I appreciate that.
We're too close. It's all about 7
They
inches.
remeasured.
That you could do.
It can happen.
So, Mr. Chair, in light of Metro Legal's recommendation, I move that we not certify the petition. And I would ask Ms. Ecke, if this motion passes, to describe what happens from the standpoint of the rights to come back. But let's do that, assuming that my motion, and let's see if the motion passes.
Yeah, we have a motion not to certify.
And for the reasons set forth in Metro Legal, the lack of certainty due to the definitions being
Good.
no longer in the code.
And so we've got a motion, we need a second.
Second.
Second by Ms. Behan. Is there any discussion on the motion? Well, I would like to echo what Mr. Murphy said, that certainty is important And obviously, you've got to make, the proponents of the petition have to make their own decision as to how they do it, but relying on something that could be changed by the council, I think, in my opinion, is not a good idea. That having a definition either within it or something where there is certainty that this is what, when the people vote on it, that's what it means, would be my preference as someone who reviews the charter with some regularity. So, again, that's not our role to tell anybody what to do, but I think as a policy matter, that is a very wise thing for anyone coming in front of this commission to do. So, if there's no other discussion on the motion, then I'd call for a vote. All those in favor, please say aye. Aye. I will also vote in the affirmative. Any opposed? Then the motion to not certify the petition passes unanimously. So this will not go forward in the current.
So let's have Ms. Ecke
Yeah, so
talk about our procedure.
if you would say then
about what
about the
happens
15
next.
days and what needs to happen next.
Yes, so since you've voted not to certify the petition, the petitioners have 15 days from today to file a revised petition. And thereafter, once they file that revised petition, then this body has 15 days to meet and decide whether or not to certify the revised petition. So that's where
So
we
last time that we had this happen, we actually scheduled our next meeting within 30 days so that we could make sure that we met the 30-day, 15 days after they have to file window so that we didn't run afoul of that provision. And I would think that we might want to talk about that
But basically,
today.
giving calendars.
Yeah.
And can we do that if it's?
Yeah, I mean, it depends on when they do file this, who knows? I
Well,
mean,
yeah, that's true, because if they
because
file
they
it
have
day
15
one,
days. If they
file it
file
day
it
one-
tomorrow, then,
Well,
yeah.
Can we make an assumption that we will file it by no later than Thursday?
No, later than.
Week, what's today?
Tuesday.
No later than Thursday, let's say.
okay, yeah, so then we could go ahead and set it within, 16, 17 days, and no will be set. Why don't we set it and tell you then when you want to file it?
Yeah, okay, that's fine too.
Let's see what everybody's availability is.
So we all are coordinated.
Yes,
Yeah, we appreciate that.
thank you.
Well, I just don't want to have a fire drill to schedule the meeting and us not have enough people here, which can happen. So if you file it on the 8th, if we met on the 22nd, we'd meet the time frame, right? Because that's
That would
2
actually
weeks.
give us, if they filed it a day earlier, we would be able
That's
to
2 weeks after
do it.
Thursday, so they have a day leeway.
So how does everyone's calendar, if you've got it with you, look for Thursday, January 22nd? 2 o'clock seems to be a reasonable time if people are available.
Yeah, I have a little conflict on
Could you do
that
it
day.
earlier or later
In the
that day?
morning,
Okay? What time?
anytime in the morning, anytime before 1.
If we did 10 on Thursday. the
10
22nd.
would work. I have something from 8 to 9. I could give you
Thursday or
about 10.
Tuesday, did you say?
Thursday, the 22nd.
That's good for me. I'm okay.
Works for me.
That's fine.
Going, pal?
Sold.
10 o'clock?
I think that keeps us within,
Sure.
as long as Saul does his part, we can do our part.
So we have tentatively scheduled.
That's the 21st.
Yeah, as long as he doesn't file it after the after the 22nd.
Then we don't have to meet.
No.
So that would, that is acceptable to everyone, and we will tentatively schedule our next meeting for 10 o'clock on Thursday, January 22nd. And Ms. Ecke, just, this is always a bugaboo for lawyers, as you well know, but 15 days is 15 calendar days.
Yes, sir.
You
15
don't
calendar
exclude
days.
Saturday, Sunday,
Correct.
Martin Luther King holiday, that it would be 15 calendar days that they have to refile, and then 15 calendar days.
15 days from today, which will be, today's the 6th. 1, 2, 3. So it has to be filed by the 21st. 21st is the deadline.
And we're meeting the next day if they file it that late,
Yeah,
but.
so that doesn't bind you to filing on a particular.
We want to give the Metro Legal time to look at it, we want you all to have some time to look at it.
That was just what I was gonna say, so the more time you can give us to look at this, the better.
Good, well, I appreciate everyone's time, I really
Thank you so much,
appreciate
everybody.
the members of the commission for your service to Metro. And unless there is something else we need to do, then we need a motion to adjourn.
So moved.
Second.
Okay, all those in favor, just get up and leave.
Vote by leaving.
Then we'll stand adjourned until the 22nd at 10 a.m. Thank you.
Thank you.
Thank you. Hi, Susan. It's been so long. I just want to clarify, whether it's the property or whether it's.
When moderator.
I guess I'm not from Boston. I
So the moderator.
know Boston Common is.
Yeah, exactly. I knew we did it last time.
I type a moderator.
But, you know, I wasn't sure.